Minnesota Supreme Court has rejected an attempt to block Donald Trump from appearing on the state's GOP primary ballot next year. The challenge was based on the 14th Amendment's insurrectionist ban, which prohibits U.S. officials who engaged in insurrection from holding future office. However, the court stated that the challengers can try again to block Trump from the general election ballot if he wins the Republican nomination. The 14th Amendment, ratified after the Civil War, does not specify how to enforce the ban, and it has only been applied twice since 1919, making these challenges unlikely to succeed. The court's ruling is seen as a victory for Trump, as it allows his name to remain on Minnesota's ballot for the 2024 GOP primary, where recent polls show he has a strong lead. However, the court did not go as far as Trump's lawyers wanted, which was to dismiss the case entirely and keep him on the ballot for both the primary and general election. In its ruling, the court stated that there is no state statute prohibiting a major political party from supporting a candidate who is ineligible to hold office. The court did not address Trump's eligibility but stated that there was no error to correct at this stage. The case was dismissed, but the challengers are still able to bring their claims regarding the general election. The bipartisan group of Minnesota voters who brought the challenge may choose to appeal the decision. The court's order was signed by Chief Justice Natalie Hudson, and there were no noted dissents. During oral arguments, some of the justices expressed skepticism about removing Trump from the ballot. Chief Justice Hudson suggested exercising judicial restraint, while another justice indicated that it should be up to the voters to decide whether Trump should return to the presidency. In response to the ruling, a spokesperson for the Trump campaign called the 14th Amendment challenges unconstitutional attempts to interfere with the election, and stated that they should be thrown out wherever they arise. Similar challenges against Trump are ongoing in Colorado and Michigan. Closing arguments in the Colorado lawsuit are scheduled for November 15. Legal scholars and former jurists from both sides of the political spectrum have endorsed these attempts to disqualify Trump from office. Regardless of the initial rulings, experts anticipate that these cases will be appealed all the way to the U.S. Supreme Court, which could ultimately settle the issue for the entire nation. The group representing the challengers expressed disappointment with the court's decision but noted that the question of Trump's disqualification may be resolved at a later stage. They plan to continue their legal actions in other states to enforce the 14th Amendment against Trump. Election law expert Derek Muller stated that the court's ruling defers the issue to the presidential primary but invites a new challenge ahead of the general election, as the general election is not run by the party. This story has been updated with additional information.